I'd like to welcome everyone to the hearing today. This meeting is called to order at 9:30 a.m. Today's proceedings are being held as a hybrid meeting by way of in-person attendance and teleconference to hear minor variance applications PLMV 2025-005 and PLMV 2025-006. The Committee of Adjustment is appointed by Council to consider applications for minor variances to the zoning bylaw pursuant to Section 45 of the Planning Act. Pursuant to Section 45(1) of the Planning Act, a minor variance may be granted, provided it meets the four tests, namely that the variance meets the general intent of the official plan and zoning bylaw, that it is minor in nature, and that it is desirable for the appropriate development or use of the land, building, or structure. The Planning Act requires that a public hearing be held before the Committee of Adjustment decides whether or not to approve a minor variance. The public hearing serves two purposes. First, to present to the Committee of Adjustment and public the details and background to the application, and second, to receive comments from the public and agencies before a decision is made. As part of a transparent public process, all submissions form part of the public record. Both the Secretary Treasurer and myself, as chair of the committee for today, will be responsible to ensure that all parties and the committee members can hear one another during the meeting. For those attending by teleconference, if at any time you are having difficulties hearing what is being said, please say so or click the raise hand button or dial *9. We kindly ask that everyone speak slowly and clearly when addressing the committee. If you're of the opinion that holding the hearing as an electronic hearing is likely to cause significant prejudice, we ask that you advise this committee at the earliest opportunity and the matter can be addressed accordingly. Please be advised that any applicant or agent that is in attendance at today's meeting for a specific application may leave the meeting once their application has been considered by the committee. An applicant, agent, or member of the public wishing to address the committee for a specific application is reminded that presentations may be limited to 10 minutes per person. If you are using a computer or electronic device, please ensure that your microphone is turned on and your audio settings are not muted. All parties will be verbally acknowledged before being asked to proceed. At this time, I'll ask that anyone who objects to an electronic hearing of a matter on today's agenda or is having difficulty hearing what is being said, please click the raise hand button or dial *9. The committee will first adopt the agenda. Would the Secretary Treasurer please read the resolution?
Good morning, Mr. Chair and committee. If I can just get a mover and a seconder for. Moved by Jean Neville and seconded by John Agate. Please, or be it resolved that the Committee of Adjustment hereby approves the agenda of the February 24th, 2025 meeting as circulated.
All those in favor? That is carried. Do any committee members have a pecuniary interest in the applications being heard today? No. There are minutes to approve from the December 9th, 2024 meeting. Does the committee have any comments or questions about those minutes? Yes, Jean.
Says no pecuniary interest declared. I declared a conflict with application PLMV 2024068 and recused myself.
We'll make that change. My apologies.
With that edit, would the Secretary Treasurer please read the resolution?
Certainly. And so instead of saying that the meeting minutes will be approved as circulated, it'll be approved as amended with that change from committee member Neville. If I can just get a mover and a seconder for those.
All right. All those in favor?
Oh, I just have to read it out
Oh,
first.
sorry.
Sorry.
Rushing along here.
Moved by John Aggett, seconded by Honoree Tall. Be it resolved that the Committee of Adjustment hereby approves the meeting minutes of the December 9th, 2024 meeting as amended.
All those in favor now? That is carried. All right, I now declare this to be a public hearing for application PLMV 2025-005, located in Part Lot 8, Concession 10, Geographic Township of Minden. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Yes, through you, Mr. Chair. So the township is in receipt of minor variance application PLMV 2025-005. This was submitted by Greg McElmoyle on behalf of the property owners Tom and Kathy Salisbury of 1020 Toboggan Hill Trail on 12 Mile Lake. The property is developed within one-story dwelling and accessory structures. The property owners are proposing to tear down and rebuild a garage, which has become damaged over time, and they're also proposing to tear down a shed. Although the current garage is compliant with the zoning bylaw, the property owners want to make the new structure more functional and therefore larger. And as a result, the garage footprint would move closer to an existing right-of-way. As submitted, the application requires the following relief from the township zoning bylaw from section 4.35 to permit a reduced setback of 0.15 meters or 0.5 feet to a private right-of-way, whereas otherwise a setback of 3 meters or 9.8 feet is required. And from section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required. The application is subject to 4 tests of a minor variance, which I will briefly review. The first is the application minor in nature? When assessing whether an application is minor, we give consideration to potential impacts of the variance that's being requested. The proposed variance, as mentioned, will permit a reduced setback of 0.15 meters or 0.5 feet to a private right-of-way. Topographic constraints, which include bedrock outcrops, as well as a couple of mature trees, as well as the configuration of the lot, which includes the location of the existing driveway, limit locating the garage further away from the existing private right-of-way. Further, the existing private road deviates to the west, so the setback to the actual traveled road would be approximately 9 feet. There are also a couple of mature trees between the road and the garage location, and so there is no sightline concern. All other setbacks required would be met, and no adverse impacts to neighboring properties are anticipated. The application is therefore found to be minor in nature. The second test is the application desirable for the appropriate development or use of the land, building, or structure. The application will enable the continued use of the property for shoreline residential uses, which are the intended use of the land. The proposed development is consistent with the built form of the surrounding area, which are also developed for recreational residential uses. And the existing developed area will be utilized, limiting the expansion to the disturbed area on the shoreline property. Therefore, the application is found to be desirable for the appropriate development or use of the building. The third test is, does the application uphold the general intent and purpose of the official plan? The subject property is designated waterfront, being on 12 Mile Lake. Permitted uses in the waterfront designation include recreation-based residential uses in the form of single detached dwellings. Policies of the official plan promote preservation of the natural shoreline as well as maintenance of character. The established setbacks to the high water mark will not be impacted by the proposed garage, and the application is therefore considered to uphold the general intent, the general direction and purpose of the official plan. The final test, does the application uphold the general intent and purpose of the zoning bylaw? The subject property is zoned shoreline residential. As noted, the proposed variance will serve to reduce the setback from a private right-of-way to 0.15 meters or 0.5 feet. The intent of the otherwise 10-foot requirement is to ensure that there's no interference between the private road and traffic. Given that the road was not centered on the actual surveyed out right-of-way and there are some intervening trees, no incompatibility is anticipated. The garage will also generally meet the setback required for the actual road itself. Lastly, the intent of the provisions regulating existing undersized lots is to ensure that the development does not overwhelm the property. Maximum lot coverage will not be exceeded, and with the exception of the setback to the private right-of-way, the proposed development of the garage meets all other setback requirements as per section 5.2 and 4.1 of the Township zoning bylaw. The application is therefore considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement. Under policies of the PPS, the subject property is considered rural lands. The PPS does not specifically refer to accessory uses, but the garage would be typically associated with those uses and therefore would be considered consistent with the PPS. Notice of this application was circulated to neighboring landowners and commenting agencies in accordance with the statutory requirements of the Planning Act on February 14th, 2025. A signed notice was also posted at the property. The only comments that we've received to date are from the County of Haliburton, and they just confirm that they have no comments or concerns with the application. Based on an assessment of the application as proposed, it appears to meet the 4 tests of a minor variance and is consistent with the PPS, and therefore it's recommended that the application be approved subject to conditions.
Thank you. Is the applicant or property owner here today or in conference?
Yes, we are.
Please state your name for the record and provide any additional information you would like to present to the committee.
My name is Tom Salisbury. My wife is Kathy Salisbury. No, that was a very nice summary. We don't have much to add.
Okay, well, thank you for your comments. Are there any members of the public who would like to speak to this application? We'll start with anyone who is attending electronically. Oh, we have no one coming in that way. Can staff please confirm if there's anyone? Oh, we already did that. Is there anyone attending in person who would wish to speak to this application? Don't see anyone here. Are there any questions or comments from the committee to the applicants, the planner, or any persons who have made presentations? No comments. Are there any further questions from the committee to the applicants? Do you have anyone want to share any comments that they feel that they have about this matter to assist us in our decision making? Yes.
I'm really happy that they're leaving a tree line between the road and the garage. So there's no problem with sight from the people. So yeah, I have no problem with it at all. I think that's a great idea.
Yeah, I thought also that that was
Yeah.
a key thing. Yeah.
May I ask a technical question? Does the fact that now the distance from the right of way has been reduced, does that set a precedent for other applications in any way? Is there a reason to maybe re-describe the right of way to the actual traveled road?
Through the chair, so I wouldn't say it's precedent setting. Every application is reviewed on its own merit. With respect to re-describing the right of way, that would be an entirely different and probably complex process. The road is within the right of way itself. It was not centered within it or doesn't extend the width of it. So I think that it's fine as is, but that would be outside of the scope of this application.
Thank you. It's just a clarification. Thank you.
And the building plans appear to be an aesthetic improvement to the present building, so that's a bonus plus.
Looks good.
Thank you. Yeah, it's nice.
All right, any further comments?
One.
Property owner. Put his hand up.
Yeah, please go ahead. You can't see me. Yes. Please go ahead with your comments.
Oh, I just wanted to mention that in fact, the road does dip outside the right of way just a little bit in a place, which is why there's such a difference. That's all.
Okay, well, thank you for that. As there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Sure. So through the chair, there currently are four conditions outlined in the report. The first just being that the minor variance only relates to the proposed garage. The second is that the construction would proceed in accordance with the plans that were submitted to the township, and which would be considered to form part of the decision of the committee. Other than anything that might need to be added for the site plan review prior to issuance of a building permit. That the building permit would be applied for within 12 months of approval of this application. And then lastly, failing any part of the foregoing conditions, that the application would deem to be refused. I do want to suggest one revision to the conditions that's not outlined in the report. Originally, when staff received the site plan, the property owners were actually hoping to extend into the right of way. And we did work with them to make sure that they're located outside of the right of way. But there was some site preparation that appears to have been done in anticipation of the original plans. And so there is a hole there for the garage. So we just want to make sure that the setback of the 0.5 feet would be outside of the right of way. So I would suggest including a condition that an Ontario land surveyor stake that setback. But that would be up to the committee to add that in.
That would seem a prudent addition to avoid any future issues should the road be changed at a later date. So could you add that
Yep.
to the recommendation? Thank you.
Yes.
All right. Do you want to read what you vote or just?
So the additional condition would say that prior to the issuance of a building permit, the footings of the garage be pinned by an Ontario land surveyor. That would be the condition that's added.
Yeah, that's a comment. All right. Hearing all the evidence before it, is the committee ready to make a decision? Yes. we are. Would the Secretary Treasurer please read the resolution?
Sure. Just before reading, I'll just confirm. So there'll be the additional condition with respect to the Ontario land surveyor. And I've also included for reasons that the tree line will be maintained and there are no sightline issues, and that the building plans will be an aesthetic improvement for that. Sounds about right. If I can just get a mover and a seconder then.
All right.
I'll just read that in full then. And just one more change. Whereas the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2025-005 Salisbury made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area, and is minor in nature, and more specifically for the following reasons: that the tree line will be maintained and there are no sightline issues, and that the building plans will be an aesthetic improvement. Now therefore it is the decision of the committee that application PLMV 2025-005 requesting relief from the requirements of bylaw 06-10 is amended to permit the following. From section 4.35 to permit a reduced setback of 0.15 meters or 0.5 feet to a private right of way, whereas otherwise 3 meters or 9.8 feet is required. And from section 4.9.1 to permit development on an existing undersized lot where additional relief from the zoning bylaw is required, subject to the following conditions: that approval of the minor variance shall only relate to the proposed new 31.2 square meter, 336 square foot, one-story detached garage, construction of which shall comply with all other applicable law. The construction shall proceed substantially in accordance with the plans submitted to the township on September 16th, 2024, put before the committee on, hold on one second, February 24th, 2025, and forming part of this decision, save and except for revisions to the plan is required for site plan review prior to issuance of a building permit. That the building permit, which is to remain in good standing, be applied for within 12 months of the approval of this application following submission to the building department of the appropriate application fees and supporting information as required by the chief building official. That prior to the issuance of a building permit, the footings of the garage be pinned by an Ontario land surveyor. And finally, that failing any part of the foregoing conditions, this application shall deem to be refused.
All those in favor? That is carried. Would the Secretary Treasurer please advise the applicant and the public of the next steps?
So through you, Mr. Chair, the next steps will be that a notice of decision will be circulated to any individuals who have requested such. There is a 20-day appeal period, and following the end of that appeal period, the applicant property owner will be eligible for their building permits, subject to completing any of the conditions in their notice of decision.
Do you have any questions, Ms. Salisbury?
No, that seems very clear. Thank you.
All right. All right, I now declare this matter to be concluded. For the public hearing number 2, I now declare this to be a public hearing for application PLMB 2025006, located in Part Lot 8, Concession 2, Geographic Township of Letterworth. Would the planner please summarize the proposed variance and any correspondence received to date regarding this application?
Through you, Mr. Chair, the township is in receipt of minor variance application PLMV 2025-006 submitted by Daryl Gallet on behalf of the property owners Joan and Keith Pelly for property access from Dockside Drive on Davis Lake and having roll number 4616-051-000-19000. The property is currently developed with a one-story dwelling and a shed, and there's also a fenced-in multi-sport courtyard. The owners are proposing to construct a one-story accessory building for a wheelchair-accessible indoor recreational area. As submitted, the application requires the following relief from the township zoning bylaw. From section 4.1.6 to permit a height of 4.8 meters or 15.75 feet, being set back 31 meters or 102 feet from the high water mark, where a maximum height of 3.5 meters or 11 feet is otherwise permitted for accessory buildings within 40 meters of the high water mark. The application is subject to 4 tests of a minor variance, which I'll review. The first is the application minor in nature? When assessing whether an application is minor, as mentioned earlier, we consider the potential impacts for variances requested. As noted above, the proposed variance will permit an increased height of an accessory building within 40 meters of the high water mark to 4.8 meters in height or at 15.75 feet. As proposed, all accompanying setbacks to the proposed accessory building would be achieved or exceeded. The location of the proposed accessory building is where the multi-sport basketball, tennis court is already located, so no significant landscaping and or tree removal would be anticipated. There is established mature vegetation at the shoreline, which would also serve to visually buffer the development, and given the setbacks and vegetation, no adverse impacts to the neighboring properties are anticipated. The application is therefore found to be minor in nature. The second test is the application desirable for the appropriate development or use of the land, building, or structure. The application will enable the continued use of the property for recreational residential uses, which is the intended use of the land. Accessory buildings are permitted in the shoreline residential zone, and the proposed development maintains the character of the surrounding area, which are also developed for recreational residential uses. Therefore, the application is found to be desirable for the appropriate development and use of the building. Does the application uphold the general intent and purpose of the official plan is the third test. The property is designated waterfront, being on Davis Lake. Permitted uses in the waterfront designation include recreation-based residential uses in the form of single detached dwellings. Policies of the official plan as they relate to waterfront areas do encourage a balance of built and natural form. And as noted, the proposed accessory building will exceed the 30-meter setback from the shoreline. The application is therefore considered to uphold the general intent and purpose of the official plan. The last test is the application uphold the general intent and purpose of the zoning bylaw. The subject property is zone shoreline residential. The purpose of the provision regulating height for accessory buildings is to ensure such structures remain subordinate to the primary use. Now, as per the application, the existing dwelling is located 29.1 meters from the high water mark and is approximately 7.3 meters or 23.9 feet in height. The requirement for the lesser height for accessory structures of within 40 meters of the shoreline is further to maintain visual integrity from the water and balance between natural and built form. Tree cover along the shoreline is expected to mitigate for any visual impacts, and as well, the accessory building will be set further back from the lake than the house, which will further lessen visual impact. So the application is considered to uphold the general intent and purpose of the zoning bylaw. The application is also required to be consistent with the provincial planning statement. Under policies of the PPS, the subject property is considered rural lands. The PPS does not directly contemplate accessory uses, but being associated with the residential use, it would be permitted. The application, therefore, is consistent with the policies of the PPS. Notice of this application was circulated to neighboring landowners and commenting agencies in accordance with statutory requirements of the Planning Act on February 14th, 2025. Notice was also posted on the property. The only comments we did receive were from the County of Haliburton, just confirming that they didn't have any concerns or further comments on the application. Based on an assessment of the application as proposed, it appears to meet the 4 tests of a minor variance and is consistent with the policies of the PPS, and therefore it's recommended that the application be approved subject to conditions.
Thank you. Is the applicant or property owner here today?
Yes, I'm here, Daryl Gallia.
All right. Would you please state your name for the record and provide any additional information you would like to present to the committee?
Yeah, my name is Daryl Gallia. I'm a good friend of the applicant who lives out of country. Like was mentioned, the sport court is existing, and the applicants would like to put a accessory building there. Their younger child, their daughter, is in a wheelchair. When they originally built the place in 2010, she was only 2 years old. Now she's 17, and the intent of this is to provide an indoor recreation for her, her family, and friends that she has also in wheelchairs that come from a camp that she attends in the summer. That's about all I have to add.
Okay, well, thank you for that. Are there any members of the public who would like to speak to this application? We would start with anyone attending electronically. Okay, and we don't seem to have anyone here, so moving on. Are there any questions or comments from the committee to the applicants, the planner, or any other persons who have made presentations? Yes, Jean.
Just your comment that no removal of the present trees was anticipated. Is that still the plan, or do you think some of those trees will have to be removed? And if so, like what percentage of them? Because it is a good site buffer, but then you have to be concerned if at some point some of them might be a danger to the building.
This question is to me.
Yes, I'd say yes.
Yeah, there should be no tree removal. The existing concrete pad is there already, which the building, if approved, will be built on. And then the driveway for access for building is right there as well. So there should be no changes in the landscaping other than like once the building's up, if they do some gardens, flower gardens or shrubs or something like that around the building. But the existing trees should all remain as is.
Are there any other questions or comments from the committee? Okay, and do you have any comments about this that we might wish to share?
This question's to me again?
No, that's to the committee member.
Oh, sorry. Okay.
No, not at all.
for me, there's no impact on the short road allowance, so that's a bonus.
Yes, it seems to be just the reuse of an existing space, more suitable for an older person. All right, with that, as there are no further comments, would the Secretary Treasurer please read the proposed conditions for the minor variance?
Yes, through the chair. So there are 4 conditions outlined in the report. The first being that the minor variance will be for the 1-story accessory building and to apply or comply with all other applicable law. The second being that the construction will proceed in accordance with the plans that were provided with the report, other than anything that might be required for site plan review prior to the building permit being issued. The third being that the building permit be applied for within 12 months of approval of the application. And the fourth, that failing any part of the foregoing conditions of the application would be refused.
Hearing all the evidence before it, is the committee ready to make a decision? Would the Secretary Treasurer please read the resolution?
Absolutely. If I could just get a mover and a seconder. Pardon me, moved by Jean Neville, seconded by John Agate, where the Committee of Adjustment considered the written and oral submissions relating to application PLMV 2025-006 Pelly made at the hearing. And whereas it is the opinion of the committee that the relief granted maintains the general intent of the official plan and zoning bylaw, is appropriate and desirable for the area and is minor in nature, and more specifically for the following reasons: that there is no impact on the shoreline and that it represents reuse of an existing area. Now, therefore, it is the decision of the committee that application PLMV 2025-006 requesting relief from the requirements of bylaw 06-10 is amended to permit the following. From section 4.1.6 to permit a height of 4.8 meters or 15.75 feet, being set back 31.1 meters or 102 feet from the high water mark, where a maximum height of 3.5 meters or 11.5 meters is otherwise permitted for accessory buildings within 40 meters of the high water mark. Subject to the following conditions: that approval of the minor variance shall only relate to the proposed new 139.3 square meter or 1,499.4 square foot, 1-story accessory building, construction of which shall comply with all other applicable law. The construction shall proceed substantially in accordance with the plan submitted to the township on January 13th, 2025, and put before the committee on February 24th, 2025, and forming part of this decision, save and except for revisions to the plan as required for site plan review prior to issuance of the building permit. The building permit, which is to remain in good standing, be applied for within 12 months of the approval of this application, following submission to the building department of the appropriate application fees and supporting information as required by the chief building official. And finally, that failing any part of the foregoing conditions, this application shall be deemed to be refused.
All right, all those in favor? That is carried. Would the Secretary Treasurer please advise the applicant and the public of the next steps?
Through the chair, so a notice of decision will be issued and circulated to anyone who's requested a copy of the notice. There is a 20-day appeal period, and following that, the applicant or property owners will be eligible for a building permit, subject to completing any of the conditions in the decision.
I now declare this matter to be concluded. Is there any other business to discuss today?
I have none, Mr. Chair.
All right. When is the next meeting?
So through Mr. Chair, currently we don't have any applications for the March meeting. So there won't be one for March. So I'll have to let the committee know whether or not there'll be one for April, pending submission of any applications.
Would the Secretary Treasurer please read the resolution to adjourn?
Absolutely. If I can just get a mover and a seconder.
We waive a lot of money.
Moved by Jean Neville, seconded by John Agate. Be it resolved that the Committee of Adjustment meeting be adjourned at 10:04 a.m. on February 24th, 2025.